Evening, everyone. It's June 4th, 2025, and this is a public meeting of the Portland Committee on Community Engaged Policing, Policy and Reform Subcommittee. And I will pass it to our co-chairs to get us started with intros for this meeting.
Okay, great. Thank you. Thank you everyone for coming tonight. And let's go ahead and start with introductions. I'll start it off. My name is Tia Palafox. I'm the co-chair of the Policy and Reform Subcommittee for PCCEP. And I've been a member since 2021. My pronouns are she, her, and I will pass it on to Conrad.
Thank you, Tia. I'm Conrad Hewlin, he, him pronouns, PCCEP member and member of the Policy and Reform Subcommittee here tonight, and been a member since 2024, last year. There we go. I'll pass it over to Kip.
Yeah, hi. I am the other co-chair of, we used to be Settlement and Policy or something. I don't know. I get confused too. So Policy and Reform Subcommittee co-chair, pronouns are he, him. PCCEP member coming up on 2 years in September. So I guess that would be 2023. And I will hand it off to co-chair Odelia. So I see her next.
Yep. Hey everyone, my name is Odelia Zuckerman. I use she, her pronouns. One of the co-chairs of the full PCCEP committee. I'll hand it off to, I think I saw Leslie.
Hi everyone, Leslie Martinez, a member of the Policy and Reform Subcommittee as well. My pronouns are she, hers, and I think I'm gonna be a PCCEP member in August. 4 years, Story.
Nice.
So yeah, been here a while now. Still learning a lot. But yeah, and I'm gonna be off camera while I eat dinner. So just letting you all know.
Okay.
Who else is here?
I see Devonte.
Okay. Devonte, I'll hand it off to you.
Hey team, yeah, Devonte Manyweather, the other co-chair for PCCEP's full committee. Thank everyone for coming tonight. I am in transit, so I will allow the others to pass it off next.
Okay. Is that it for the PCCEP members tonight?
I think so.
Okay, let's pass it on to city folks to please introduce yourselves.
So I'll get it started, and anyone from PPB or anywhere else in the city, please feel free to jump in after me. I'm Dory Grabinski, PCCEP Program Manager.
Thank you. I'm scrolling. Yeah, go ahead.
Sorry. Thanks for having me. I'm Ashley Lancaster. Can everyone hear me? Sometimes these headphones are a little spotty. And I head up the policy development team at PPB. I will pass it to Chris Lindsay.
Hello, everyone. My name is Chris Lindsay. I'm the Captain of Internal Affairs for the Portland Police Bureau.
Thank you. Any other folks from the city of Portland or PPB?
Yes, sir. I forgot to pass it on to Deputy Chief Chris Jovic. Your sound doesn't appear to be working, sir.
Can we unmute him?
Do you want me to go, Tia?
Sure, Heidi.
Okay. Heidi Brown. I'm with the City Attorney's Office. I use she, her pronouns, and nice to see all of you.
Great, thank you.
If I may, this is Mac from Councilor Canal's office. She, him pronouns, and thank you.
Thank you. Chief Jovic, are you available to turn off your mic or turn on your mic?
Sound check.
And can you introduce yourself?
Hey, good evening. Chris Jovic, Deputy Chief of Police.
Thank you so much for being here. Okay, we have is there any independent monitors here tonight?
Hello, Antoinette Edwards, Associate Monitor.
It's good to
Great,
see
thank you.
everyone.
Thanks for coming. And if we covered the city, PPB, and monitors, anyone else here from the public, please feel free to introduce yourselves, or please write your name and your position in the chat. And that will be it for the introductions. And moving to community agreements. Our community agreements for PCCEP is listen actively and respectfully, share airtime, be present and open to new information and perspectives, assume positive intent, respect each other, respect the group, speak your own truth, communicate directly, honestly, and respectfully, ask questions to clarify, call out bias, be okay with ambiguity. The overview of today's meeting is we'll start with updates. We're going to really dive into the Portland Police Bureau Directive on exculpatory evidence. And then we'll open up for public comment at the end of the night. The first update is PCCEP attended and supported the May 28th town hall on the Independent Monitor's first compliance report. It was hybrid, so some of us, there was quite a few people who came in person, which was nice. And we also have people online. We had a great turnout, and you can read the draft report and the monitoring plan online if you'd like to go to portlandpolicemonitor.com. PCCEP has received quite a few public comments noting that there's a gap in compliance monitoring during Q2 of 2024, while a settlement agreement was transitioning from the former monitoring body, the COCL, to our current one, the Independent Monitor. This period included the Portland State University protest, which I believe was in May 2024, and which resulted in a spike in interactions between civilians and police, which led to about 30 arrests. PPB and the city attorneys also failed to properly share comprehensive video evidence with prosecutors, resulting in possible Brady violations that led to the dismissal of charges against PSU protest defendants. Oregon Senate Bill 238. This bill is to expand drone policy that passed the Oregon House under consideration in the Senate as of May 2025. It authorizes police to deploy drones without a warrant in situations like 911 calls, emergencies, and property threats. It shifts deployment authority from courts to law enforcement. It may facilitate increased monitoring of public spaces. There's no clear limits on data retention, sharing, or public access to footage. Okay, those are our updates for tonight. And now we're going to move into the meat of our meeting tonight. And I'll hand it over to Kit.
Oh, sorry, Tia, we do have just a brief couple of minutes if anyone has questions about particularly those last two updates. They're mostly to inform, particularly the second one, that PCCEP has heard you around that all of those public comments. And that is mainly the update and is exploring that issue, but no movement there, just that they wanted to acknowledge that they had heard you on that. But yeah, we have just a couple of minutes if anyone has questions or comments.
Okay. Great, thank you. Thanks for slowing me down. Any comments from or questions about the updates that we just shared?
Yeah, go ahead, Babs.
Hi, can you all hear me okay?
Yes, we can.
Okay, about that Senate bill that was just mentioned. Not sure I understand current status, and can we public still submit written testimony on that?
Yeah, so my understanding of it, and I'm not an expert, I am aware of it, it is an expansion of current drone use capabilities from a state level. Different municipalities have their own abilities to use drones, I think. And you can still contact your representatives or anybody else's representatives for that matter to provide feedback and input still. I don't have the dates in front of me, but we wanted to bring it up because it is something that is concerning from a surveillance standpoint. And the ACLU Oregon has also been posting on it recently.
Okay, thank you. I forgot to say I'm a 76-year-old lifelong Portlander, currently in District 2. My representative is Tana Sanchez. My senator is Lou Frederick. So I will be happy to contact them, voicing my opposition to this bill. Thank you.
Thanks, Babs.
Barb? Barb, we can't hear you, so you may be on mute.
My microphone, I'm not on mute because I'm trying not to use that word, but my microphone is definitely off and I was fighting with it.
Okay.
Thanks, Frida. So, Ophelia, I'm not sure if we had this discussion or not, but I'm so confused about why that period of time wouldn't be covered in the annual DOJ report.
Yeah, I will defer to Heidi Brown to answer that question about the gap because I think, yeah.
Yeah, that's fine. I just wanted to acknowledge that we talked and I heard you. I'm not accepting of your answer.
Fair enough. Yeah.
Yeah. Hey, everybody. So when we amended the settlement agreement, we all understood there could be a gap. So COCL did their Q1 report, but DOJ wasn't doing assessment because we had already switched to the monitor, but or we're in the judge had approved it and we were in the process of hiring the monitor. So they were no longer technically the monitor, but we were in the process of interviewing and seeking interest in that position. So there is that period of time. We kind of knew there would be a bit of a gap in actual compliance assessment, although COCL did one report and then kind of did their final analysis, but it didn't go through the full process. So.
Yeah, and to that end, Barb, we will input from you and others, and if we have more momentum on this, it's something that PCCEP is considering picking up, looking at, and asking more documentation to at least detail what had transpired through our committee. So if people are interested in that, please let us know.
All right, turn it back over to the co-chairs.
Thank you. Okay.
Okay, next slide, please. So our discussion today is going to center around a directive that was up for second review on exculpatory evidence 0320.00. The understanding that we had that in the first review round, which was 2 months ago, there were the copy that I unearthed recently had no changes that I was even aware of to it. So between the first review and the second review, there are substantial changes being suggested to be made. So the PPB has been willing to extend the feedback timeframe by an additional 2 weeks so that we can have this conversation tonight, learn more about it, and find out more about why the changes were put into place, and hopefully have a fruitful conversation around it. Next slide. So we have folks from I'm sorry, I'm going to get the organization wrong because I don't have it in front of me and I have it memorized. But Oregon Justice Resource Center, a Public Defenders Association, Metropolitan, is that it? Okay,
Yeah.
thank you, Grant. And also Ashley from the PPB policy division, other folks from PPB to have this conversation and walk through what the changes were. We have the ability to develop a recommendation if our communities feel like this is a direction we should take based on input and what is codified in the directive at the outset or at the end of the 2-week period. PCCEP does have the ability to request a review and write recommendations on any directive out of cycle. They're generally on a 2-year review basis, but our charge allows us to write a recommendation and, as it says here, get a formal response within 60 days. So depending on how things transpire tonight will depend on what PCCEP might do next. And okay, thank you. Here's the invited guests. I don't need to read to you, but we'll have everyone introduce themselves. And we also have a presentation to start with. Next slide, if you would. Yeah, we have a presentation from the Metropolitan Public Defender's Office, and then we'll have perspectives from the different parties we invited, and then we'll have an open discussion around this. So if, can we start with the Metropolitan Public Defender's Office and have them introduce themselves, and we can move forward with then our OJRC. I'm never going to get that right in my head. And also the PPB, and then we can go into the presentation.
Yeah, that sounds great. So I'll start. My name's Grant Hartley. I am the Multnomah County Director for Metropolitan Public Defenders. I will pass it over to Grant Cole.
There we go. Can people hear me okay?
Mhm.
Okay. I'm Grant Cole. I'm the other Grant over at Metropolitan Public Defender. I am responsible for attorney training here in the downtown office.
Hi everyone, I'm Drew Flood, he, him. I'm one of the major felony attorneys here at Metro, and I am one of the main attorneys who has been litigating these issues, including kind of the decision in January or February, excuse me, that we think sparked a lot of the considerations of revisions to this policy, which we'll be talking about in a second. Nice to meet you all.
Thank you.
Great, thank you. And Juan, I see you from OJRC.
Hi, folks. Thanks for inviting me. Juan Chavez. I'm an attorney and director of the Civil Rights Project at the Oregon Justice Resource Center, which is a mouthful. I agree.
Thank you. And Ashley, do you want to introduce yourself and folks on your team?
All right, it always takes me a second to find my microphone. Apologies. And now my camera isn't working mysteriously. Ashley Lancaster, I lead the PPB's policy development team. I have the deputy chief here with me as well. Chris?
Oh.
Me again. My microphone is working again. That sounds good. Chris Jovic, Deputy Chief of Police. And we have some members from the City Attorney's Office and the IA captain here as well.
Perfect.
Awesome, thank you. So would the grants like to get started with their presentation?
That sounds great. Let me just
The grants.
share my window here. Yes, it does make it a lot easier. Okay, is everybody able to see those slides?
Yes.
Okay, great. So again, thank you for having us today. We really appreciate it. So I'm just gonna pull up a couple notes here. So, as I said, I'm the director of Metropolitan Public Defenders. So, our office operates in 2 different counties, here in Multnomah County and in neighboring Washington County. I am the director of our adult criminal division here in Multnomah County. So, if folks are charged with crimes, we are the largest and oldest public defender in the state. And so we are appointed on, I believe at this point, the majority of the cases in Multnomah County. And we asked to present at this because of, as Drew said, recent litigation that we engaged in regarding this PPB directive, and then learning about the proposed changes just months after that. We wanted to come express our concerns, but also sort of explain what Brady is, what exculpatory evidence is. And so we're sort of just going to start with just a big explanation of all of this stuff. At the same time, we are lawyers. I know not everyone here are lawyers, let alone criminal defense attorneys. So please, if any of us start, just speaking in legalese or using acronyms that you don't understand, please interrupt us, let us know so that we can clarify those things. I want to start sort of with the big picture. When you are charged with crime, it's important that your attorney has all of the information that the state has about the charges against you, right? That's how a defense attorney like myself or like Drew or Grant, that's how we prepare a defense. And so that includes the police reports, the videos, any statements made by witnesses, all of that. That stuff is generally known as discovery. In addition to that, it's any information that the state has about witnesses as well. So if they know that a witness has a criminal history, they need to provide you with that criminal history. And part of that, as I believe Grant will explain in a moment, is what's called Brady evidence. Brady evidence is exculpatory evidence, so that evidence that tends to show that you didn't commit the crime or mitigate your guilt, as well as evidence that could be used to impeach a witness, so call into question their credibility. And so the way that this is important for this directive is that police officers are witnesses in pretty much every criminal case, right? At least one police officer. And we know that police officers have misconduct issues. And those misconduct issues can range from excessive force, evidence mishandling, bias, dishonesty, and all of those. It's important if they have that in their background for the jury to hear about it so they can make a determination about that officer's credibility as they're testifying. And so that's the basics of what this evidence is, And the policy here is about how this evidence is shared between PPB and the Multnomah County District Attorney's Office. And so we're going to go into some of the detail around this type of evidence, and then we'll sort of walk through the current directive as well as the proposed changes. And so I will hand it off to Grant.
Hi, everyone. I just want to echo Grant Hartley's initial expression here, thanking you all for having us at this meeting. We really appreciate the opportunity to go over this stuff with you all. I'm going to move somewhat quickly through the basis of the law here, just because I don't think that fundamentally there's going to be too much disagreement in terms of what Brady encompasses and what that means. The law that we're dealing with here, it is fundamentally comes from this U.S. Supreme Court case, Brady v. Maryland. This was a case that was litigated back in the 60s, and it's been affirmed many, many times over in the United States Supreme Court. It's also been affirmed repeatedly in the Oregon Supreme Court. The basic standards are on the screen. This actually comes from a case that was then reaffirming Brady. This is from Strickler v. Green. That basically goes through the basic elements of what can form a Brady violation. The first is that, as Grant was talking about earlier, we're talking about evidence that is either favorable, that is favorable to the accused, and it can be, and favorable is intentionally a really broad term here. It can be material that shows, maybe someone identified someone differently at a crime scene, something like that, which would go into that category of what would be exculpatory evidence or evidence that directly shows that this person who's accused of a crime actually didn't commit it. So there's that bucket within favorable evidence, but there's also evidence that either mitigates that person's guilt, and then evidence that we're really focused on here is evidence that is impeaching, or evidence that can undermine the credibility of any witness that the state is presenting at trial. That Brady establishes essentially here that the state is obligated to present, to inform the defense of anything that they are aware of or should be aware of that could potentially undermine that witness's credibility. The next element here is that the evidence was not handed over. That this is how a Brady violation would be formed, is if the government fails to hand that over. And an extremely important part of that failure is that there's no part of the analysis here that involves the state or the DA or any individual DA acting intentionally. It doesn't matter, as far as the court is concerned, whether or not this particular assigned prosecutor on a case knew of certain evidence and then chose to withhold it. I mean, that can happen. That would certainly be a Brady violation, but it is not a requirement for a Brady violation. It includes information that the DA or that assigned prosecutor has a duty to go out and learn about. And then if they fail to do that and then subsequently fail to hand that over to the defense, that is a component here of what creates a Brady violation. And then finally, does this failure to provide the evidence cause prejudice? And another important part of this aspect of the court's analysis is that prejudice is also very broadly defined. This doesn't have to be evidence that would have clearly changed the outcome of a trial. All that we're talking about here is evidence that, is this something that the defense was entitled to? And is there any way where maybe this evidence could have been used to create further investigation from the defense? Is this evidence that the defense could have used to potentially question this witness about on the stand? Is there some other witnesses that the defense could have been reaching out to as a result of had they been informed of this evidence, that would have changed some of the contours of the case? Now, and it is important, the other distinction here that I think is important for people to understand is that the way that this law operates is different than a lot of the law that governs discovery. And if you can move to the next slide. Most of the law around discovery in the state courts applies to what the state or what the defense is going to use at trial. That is generally the thing that governs this. That concept breaks down when we're talking about Brady. Fundamentally, even the state, if there's not going to be a situation where they're going to be presenting at trial all of this exculpatory evidence or all of the evidence that undermines their own police officers. That's not what they're presenting at trial. But Oregon, as has every other state since Brady has come out, has modified their discovery statutes to make sure that the governing principles here are not just what the state is going to show at trial, but it also includes, as what's on the slide here, that the state is required, even if they're not planning on showing evidence that undermines their own officers, they are required to disclose to the defense any evidence that is supportive of the defendant's innocence. And certainly under B and C there, or really C is what I'm focusing on, any evidence that could potentially impeach or undermine the credibility of any witness that the state calls at trial. And in almost every single criminal trial that occurs in Oregon and everywhere else, really, the vast majority of the time, the state is calling police officers to the stand. And so what we're talking about here, where the focus of this policy is around evidence that is in possession of the state that has the potential of undermining the credibility of the state witnesses, including police officers. Unless Grant or Drew have anything else to contribute there, we can move to the next slide here. So the way that the law operates is that the court essentially, as a result of Brady and a result of the Oregon statutory law, imposes this obligation on the DA's office to provide this material to the state. And the practical reality here is that that forces then the DA's office, in this case, Multnomah County DA's office, to work with the various law enforcement agencies that they take cases from. In Multnomah County, we're talking about PPB, Multnomah County Sheriff's Office, Port of Portland, Gresham Police. All of those agencies have their own policies that govern how this material is shared and that account for the fact that the law enforcement agencies are required to hand this information over to the DA's office, and that the DA's office is required to seek this information out. That the court has essentially ordered every prosecutor, they are on notice that you have to go and seek out this material within whatever law enforcement agencies they work with, that they have an obligation to find this information and then subsequently provide it to the defense. We're going to talk about this more in a second, how providing things to the defense at this stage does not mean that it is subject to public disclosure. It just means, and it doesn't even mean that the DA's office can't call some witness who has a, some officer who has a pending investigation against them. They absolutely can call that. But if that's going on, the material has to be disclosed to the defense. The reality of that, the investigation is ongoing, the nature of that investigation, that's the type of material that's fundamental to Brady that must be disclosed to the defense, according to the U.S. Supreme Court, Oregon courts, and Oregon statute. All right, I think we're moving to Drew for the next few slides here.
Thanks. Yeah, I was looking for my mute. Hey, everybody. So I just want to start with why is having this policy important? And it goes a little bit to what the deputy chief posted in the chat right now. And I think we'll try to be addressing information we're obviously learning on the fly about what MCDA is saying. I want to be front and center where I say that I think that MCDA is in part pushing for this policy because they don't want to have records that they will then have to give over to defense lawyers that are critical to defense cases. And it's hard to understand the sequence of events in this case and not come to that, or into the situation and not come to that conclusion. The important background, and this goes directly to the comment about MCDA's statement, is that this policy was not created in a vacuum. This directive was created in response to a 2017 IPR review, a report that had a few different things that it talked about. And I obviously didn't want to include so many different clips from the report in this presentation, but it comes up just based on a really quick Google, and the title of the report, just in case anyone wants to look at it, is the 2017 Independent Police Review Report Policy Review, Portland Police Bureau, Compliance with Brady versus Maryland. It came out in April 2017. And part of what was going on at the time, what the report recognized, there was no existing policy on what specifically PPB was doing to make sure Brady information got over to MCDA. An important thing, I think, for everyone to understand, it is well established that misconduct records for officers are Brady information. Now, how much misconduct records should be turned over to the defense and therefore be used potentially at trial or in negotiations, that is a question for DAs to answer. That is a question for judges to answer in reviewing documents. But there's no question this is a category of records that constitute Brady, that are important for criminal defendants to have. And what the 2017 report talked about is that in Multnomah County, there was a long-standing failure to turn over these types of records to defense lawyers. Defense lawyers practicing in state court couldn't even remember ever getting misconduct records for the folks who were interviewed by IPR in that 2017 report. Now, you can contrast that with what the report talks about the U.S. Attorney's Office and the federal prosecutions that happen in this same jurisdiction. In the U.S. Attorney's Office, those handle federal cases, and the report talks about how there was a practice of assistant U.S. attorneys asking PPB to look at misconduct records, reviewing those records, and then giving over records that they thought could be used and were important for the defense to have from a Brady standpoint. They could be used as impeachment, and making sure that they were fulfilling their constitutional obligation. And why that all matters, it's absolutely possible for MCDA to do this, to use its discretion, look at these records, separate the wheat from the chaff, and decide what is required for them to turn over under their constitutional obligations. We're going to talk more about all the different checks and balances on this process to make sure that misconduct records for officers who we recognize are public servants aren't just going out into the world for anyone to use. There are so many stops before any information becomes public in this process, but I think it's important to recognize that that first step really needs to be a prosecutor, a lawyer, reviewing the materials to see if they need to turn it over. Grant, I think you can go to the next slide. And I think there should be one in between, unless there wasn't. Is there a slide with that one? Yeah, that's what I want. No, that one. Yeah, thank you. This is a clip from the existing policy. This is the introduction to the existing policy. And as far as I can tell, I think it's being cut from the revisions to the directive. It's unclear to me if there's going to be a different introduction. I'm not so familiar with PPP directives to say that for sure. But it talks about how it's directly in response to this 2017 Independent Police Review Report and talking about how important it is to have a written policy. And it also talks about how multiple people worked together to make this policy. And there was a long process to make this policy. It was posted in August 2020. There's a second review in November 2020, and it doesn't go into effect until June of 2022. Obviously, there's lots of things going on when this directive is being discussed and going into effect, including the wake of the George Floyd protests, and I think the widespread understanding that there was a significant amount of misconduct, and that those records need to make sure they're finding their way to the right places when it comes to criminal prosecutions. But the critical thing I want to highlight for this committee and for the public is that last sentence on this page. You see, in developing and reviewing the directive, the Bureau worked with a number of stakeholders, including DOJ, IPR, and the Multnomah County District Attorney's Office, as well as PPBs, as well as the collective bargaining units. So for MCDA to make a comment that they're not coming to this meeting because they didn't understand the intent of this policy and they didn't understand what it said is ridiculous. And I think that is incredibly frustrating for us who have been working on these issues and trying to get MCDA to be in compliance with the already existing policy that they have completely ignored after already knowing about it. I think I'm ready for the next slide, Grant. So that goes to the existing policy. And I think that the existing policy, thank you, Grant. The thing I want to highlight, we've been talking about these 4 categories: dishonesty, bias, evidence mishandling, or excessive force. There are obviously other types of misconduct records, and I want to talk about that in a second. But what I want to start by explaining is that the policy is already narrowed to those categories being the ones that are affirmatively turned over to the DA's office, so that they are definitely reviewing those categories of misconduct records to see whether or not that should go to a defense lawyer. Why that's really important. These are exactly the types of misconduct records that can be relevant in criminal prosecutions, that are most often relevant to a defense. Dishonesty, pretty relevant across the board. Bias, especially relevant depending on the demographic of the criminal defendant. Evidence mishandling, relevant across the board, but honestly probably comes most at play when an officer is a person who is in charge of collecting evidence that is important to criminal prosecution. I want to give an example. Certain police officers are called to scenes of shootings to collect bullet fragments, to collect different pieces of physical evidence from the scene. If that officer has improperly been accused of improperly handling evidence in the past, that is something that a defense lawyer and a criminal defendant should know, so that they can highlight that for the fact finder at a trial, or, and I want to take a step back and make one point on this, or bring up in negotiations. Most of our cases don't resolve at trial. Most of the time we're meeting with DAs, with judges in confidential settlement conferences. We're talking about how can we resolve this case. The number one thing that changes the DA's mind about how to resolve a case is a weakness in their case. If we don't know about a critical weakness in one of their main witnesses in a case, that is depriving a community member, a criminal defendant, of the ability to fairly negotiate their case. The last category I want to talk about, excessive force. Incredibly important category for certain kinds of prosecutions, especially. Prosecutions like resisting arrest, where a defense to resisting arrest is if the officer is using excessive force on you. A prosecution like assault on a public safety officer, same type of defense, aggravated harassment, any type of charge where the officer is essentially the victim of the crime, which we see a lot. That type of charge, it is important to know whether or not that officer has a history of using too much force on other people, to know whether or not that might explain the amount of force that they were using in this specific encounter. The other thing it might explain is when that officer is talking about, hey, I had this interaction with Drew and Drew was acting really crazy, and that's why I had to use this amount of force on him. And that officer is testifying about what happened at that trial against me. If that officer knows that he's been investigated 4 or 5 times for excessive force in the past, you can be sure that that's in his head when he describes what he did or didn't do in his encounter with me, is that he has been in trouble before for this exact issue with his employer. And that's why this current policy is so important to ensure broad disclosure for these types of categories. Now, the next slide says, what we are not talking about under the current policy is broad issues like like HR issues, like a complaint from an officer that they're subject to discrimination in the workplace, that they were tardy for some shifts, that they failed to report, they failed to file a police report in a timely manner. All of those things I think are not things that we would expect to get from MCDA. Now, what's important under the current policy, MCDA, the prosecutor, they can look at a person's general misconduct records and files, but they have the discretion as the lawyer who knows their case of what they should turn over to the defense. That's not automatically going to us. Next slide, Grant. The last thing that I'm going to discuss here, or I guess I have 2 more things, is 3 more things. I'm going to move faster. These types of findings. So the current policy says that these are be affirmatively reported in these categories regardless of the outcome. And that's really important because it allows for broad disclosure. There are different kinds of findings, and I'm sure that the folks from PPB can explain this better than I can, so I'll kind of move over it a little bit quickly. There are different types of findings that can be made in a misconduct investigation. It can be sustained, where a preponderance of the evidence, which means more likely than not, proves a violation. It can be not sustained, which means just that there wasn't enough evidence to prove the violation, but not necessarily that the person, it's proven that the violation didn't happen. And that's when you get into the exonerated and unfounded categories, which is where you can show either by enough information that someone was policy compliant, that's exonerated, or unfounded is where the allegation was false or not credible. All to say, at least from my perspective, there seems to be overlap in these categories to some extent. It's at least somewhat murky to me of exactly how something lands in what category. The important thing is that I think the district attorney, the prosecutor, needs to be able to review the underlying allegations and actually see what the officer was being accused of to understand, is this the type of information that needs to be turned over, not just what the final outcome was. And why that's especially important is one of the things that the 2017 IPR report talked about is that the finding doesn't necessarily tell the full story, because there can be recategorizing of conduct as part of negotiations with officers when you are deciding kind of how a misconduct investigation is going to land. And again, I don't want to get over my skis. I know we have folks from IA here that I'm sure can explain that better than me. But I think the important thing is that regardless of the outcome is critical language to keep in a directive, and the new directive revisions eliminate it. Grant, I think I'm ready for the next slide. So this is the context for the changes to this policy that I think it's important for the committee to know. In February, Judge Lucero dismissed a case, State versus Parzybach. There was a news story about it in OPB, and I think covered more broadly. in part for the failure to turn over officer misconduct records. And what happened in that litigation is that we as defense lawyers, myself and Henry Ostrom Shaw, my colleague, did what we normally do to get misconduct records, which was subpoena the records from the city, and then the city fought us about whether they should be turned over. During the course of that litigation, we learned that this policy existed, a policy that we had never been kind of actively notified about by PPB or MCDA, and it clearly put these types of records in the possession of MCDA. And it showed that MCDA, for certain categories of misconduct records, had these records because they were being affirmatively reported to them, or at least was supposed to have them, and should be giving them to us. And so Judge Lucero recognized that because MCDA wasn't doing its job under Brady, that was part of the reason that the case should be dismissed. Now that happens in February, and at the time, we have MCDA supervisors at the hearing admitting to us, we didn't know about this policy, or we weren't fully aware of the scope of it, and we need to fix this. We know that this is a problem. Then we see in March that there's the first universal review and the policy is the same. Okay, great. We expect that MCDA is putting in place and with PPB some policy and procedure to make sure that they are actually reviewing these records and getting them to defense lawyers the way they are supposed to under the Constitution. But then we see, just when I was talking with Juan's colleague, Claire Powers at OJRC about the policy, suddenly she noticed that the second universal review dramatically changes the directive with no explanation. And Grant, I think the next slide is. And there's a lot of concerns, which Grant will explain more, the nuts and bolts of how the policy has changed, but just zooming out. There's a concerning lack of process to the proposed revisions from our perspective. The existing policy, as I've already explained, was drafted in 2020. It went into effect 1.5 years later. The DOJ, IPR, MCDA, and police bargaining units were all involved in drafting it, and there was extensive public comment that talked about how MCDA, a prosecutor, a lawyer specifically, should be the one deciding what type of material is turned over, not police officers who are colleagues of the specific people that these misconduct records are about. And you can see that in the comment I pulled out here from the existing policy, which talked about how commenters asked the Bureau to ensure that it allowed MCDA make all decisions about materiality. MCDA prosecutors need to be the ones looking at these files. They can't be shielded from them so that MCDA can just claim willful ignorance and we don't actually know what the files say. The new policy, it's unclear who exactly participated in the revision process and how. Again, it directly contradicts the stated purpose and public policy on the public comment on the existing policy. And then the last thing is, I think it's hard to see all this as anything less than MCDA advocating to receive less information of these misconduct records so that it doesn't have to comply with the policy that's already existed for over 3 years and that it's never followed. And it doesn't have to give over misconduct records in the way it's supposed to, and the way that honestly, whatever the policy says, it has to. But it's just trying to make it harder for itself and bury its head in the sand on what misconduct records are out there for its critical witnesses, and therefore not have to give them to defense lawyers and defendants when it might affect their case. And I think it goes back to Grant Cole.
Oh yeah, that's me now.
Talk about the new policy.
Yeah, I'll take over from here. And you know, and I want to take just a quick minute. I've seen a few questions come up in the chat that I want to just pretty quickly address. There was a question about how are these allegations potentially admissible in court? I'm not sure we get to this later in the presentation, so just briefly, the answer is very often they are not admissible in court. The reality is that the majority of the time, they're not going to be relevant for the trial. The only times that they would be coming into court, well, I'll back up even a little bit further. The answer to like being able to introduce any material that we would receive as part of this process, like documents themselves, the answer to whether or not that would ever be admissible in court is I probably never. But really, the big problem here is that we can't review any of these materials to determine those situations where it is relevant to the officer's testimony and it is relevant to the bias of that officer in the particular case. You can imagine there are many cases it's not relevant. The police are showing up after a burglary occurred, they're taking people's reports, and their credibility really isn't that much at issue. We have many, many cases where people are charged with resisting arrest, where they're charged with attempted assault on a public safety officer, and where there is, it's only in the last year where body cam has actually been deployed amongst PPB. It is exceedingly common that there are cases in which the defense of our client comes down to a credibility determination between my client and the police officer. And it is absolutely critical in those situations that we know that this officer is currently being investigated for the very thing that they are accused of doing by my client. That would be the kind of situation in which this, although I wouldn't be able to admit the documents that we receive, but me asking the officer questions about that disciplinary process would be fair game. Quickly here with this slide, that we really want to point your attention to both policy number 1 here, as well as policy number 4. What I think is important is how, so these were the policies that were codified in the original passage of this policy. They make it really clear. The policy number 1, it's hard to read with this red line, but it says that this policy exists to ensure timely disclosure of an appropriate scope of exculpatory and impeachment information to ensure that trials are fair. I think it is extremely telling that this version of the policy seeks to delete that line. That line should not be controversial. That is fundamental to any system of law that ensures a fair trial for the people that are accused of crime. For point number 4, it says the policy as originally codified said the Bureau recognizes that materiality is a legal issue to be decided in court, and courts decide whether something is Brady material retrospectively. Therefore, the Bureau shall err on the side of disclosure and allow prosecutors to make decisions about materiality. Now, we have many issues with how we anticipate the DA's office making those decisions about materiality. Here, we're not even getting there yet. And this is another example of how telling it is that this change in the policy seeks to delete what should be a absolutely non-controversial statement that is upheld everywhere, that respects the rule of law under Supreme Court precedent and Oregon precedent under Brady v. Maryland. And I'll pass it over to Grant, other Grant. Oh, wait. Yeah, I think we can kind of go through this here, Grant, and this is
think
really
Grant partly
yeah.
can just cover this when he covers the flow chart. That's probably going to be simpler.
Yep.
Yeah, for sure. I mean, this slide is just really to show the extent of the changes that occurred. And again, this occurred after that initial review, and in the second one, it really just guts the policy. And so what I want to do is take a moment to go through this policy and explain exactly what it does and exactly how it's changed. And so I've done so through a flowchart because that's how my brain works. So I hope yours is too. So the policy requires the Portland Police to affirmatively report to the DA's office any potential Brady material, and it calls out these specific 5 areas, right? Crimes of convictions or criminal investigations, allegations of dishonesty, allegations of bias, allegations of evidence mishandling, and allegations of excessive force. And that is regardless of the outcome of those internal investigations, right? And Drew explained well why that outcome should not be a determining factor. I mean, a big reason is, some might argue that the police have an incentive to not find a violation. And so, all of that information is turned over, but it's turned over to the DA's office, right? They provide all that information to the DA's office. Supposedly, that's what they were supposed to be doing. We don't believe that has actually been occurring, despite this being in place since 2022. But they provide it to the DA's office. The DA then reviews that information regarding a specific case to determine whether or not that information meets the standards of Brady and our statutory obligations. And again, we went through sort of what those things are. Now, in making that determination, because sometimes that basic information is not enough, it also gave the prosecutors the ability to request to review criminal, administrative, and supervisory investigations to make Brady determinations. And I think this is where, you know, a lot of the statements we've seen from the city, from PPB, from MCDA, you know, they're saying, well, they're turning over the full personnel file. That's not the case. What is being turned over is the allegations, and then the DAs who investigate that allegation to look for that Brady material can access those personnel records to take a look and to see what's in there. But again, that information is within the DA's office. They are required to do a confidentiality agreement before reviewing any of that information. At this point, again, defense attorneys don't even know about it. DA makes a decision. Is this Brady material or not? If it's not, no materials are provided to the defense. Defense is none the wiser. Those materials are, I'm assuming, I don't know the DA's process, but I would assume those materials are then destroyed or sent back to PPB. If yes, then the materials are provided to the defense pursuant to a protective order. And this is, you know, where, you know, the concerns about the confidentiality rights of the officer comes into play, because the defense attorney that gets this, there is a court order that says that you can only use this in very specific ways. You cannot disseminate it, you cannot leak it, you cannot do any of those things, or you will be in a lot of trouble, and your bar card will be in a lot of trouble. And so this information is incredibly protected, even once it's turned over to the defense attorney. But at that point, that means that that information is discoverable. That doesn't mean that it will even see the light of day, because a judge still has to make a determination that that evidence is probative. In other words, you know, it's important to the case and it's relevant. And that is whether it's admissible. And only then do we get to ask the officer about that incident. And we're, as Grant said, we're not introducing those records, we're simply asking these questions. And so this is the basis for the attorney to ask permission to ask about this misconduct. These records are not being disseminated, they're not being shared with the public, with the media, they're being held in a private file by defense attorneys. So that is the current process. That is how it currently exists. The changes to it is they've gotten rid of three of the sections, right? So bias, evidence mishandling, and excessive force. Those are no longer going to be provided to MCDA, assuming that they were being provided in the first place for this directive. So criminal convictions and criminal investigations still will, and allegations of dishonesty still will. Those will go through that same process. The DA will review them, determine whether or not it meets Brady. But now the policy, the new revisions, gets rid of their ability to go into those personnel files and investigate further on these allegations. They still make a determination whether it's Brady. If it's not, again, materials go nowhere. If it is, they go to defendants, but they still need to be found admissible to ever see the light of day. Now, for those other three sections, for the bias, evidence mishandling, and excessive force, those are only now provided to the DA's office if PPB itself deems them to be credible allegations. And that decision is made by an officer or a designee within, I believe, the internal affairs, but I'm not positive. The captain might be able to correct that. When they are making that determination, here are the considerations that are laid out, but this is not an exhaustive list, so they can rely on other things. But if you look through these, as somebody who deals with legal standards on a daily basis, I can tell you these are very squishy. I don't know if anyone here knows what inherent plausibility of the allegation would mean, but when you have a squishy standard, it means that it's difficult to enforce. And so the PPB will review the allegations, will determine based on, the weight of the witness accounts, including their demeanor. Demeanor is not generally something that you should be using to judge the veracity of an allegation. So they will use these to determine whether or not it's credible. If they themselves find the allegations credible, only then is it provided to the DA, and then the DA does the review of it. They can't double check anything. They can't go access this information, and then make the determination of whether it's Brady. If they don't, if it's not credible, then no materials are provided to MCDA. No one knows anything about these allegations. And because they've gotten rid of this 3.31 that allows the DAs the ability to review these files, there's no way to even find out how that credibility determination was made. And so there's literally no check on this determination by PPB. And that results in not only no materials provided to MCDA, but also these materials will never be provided to the defense that either. And again, I think the important part about this is that, you know, this limits dramatically the type of records that MCDA will get, which should be concerning. A prosecutor should want to know as much information about the case, about its witnesses, as it possibly can to ensure that it is pursuing a righteous prosecution, that there is evidence beyond a reasonable doubt. If it is limiting the information that it has access to, the information it can review, that should be concerning to everyone. And again, I've sort of talked about this, but I'm going to actually hand this over to Grant.
Yeah, and I'll be quick here too. But the big thing that we do want to reiterate is that just because this material is provided to the defense does not mean that it is then subject to public disclosure. In fact, the base rule is that it is not subject to public disclosure. Anything that is subject to a protective order means that a lawyer who releases it could go to jail. They certainly could lose their ability to practice law. These are things that we take exceptionally seriously, and we're also really used to handling material that is subject to protective orders. It is routine for us to have material that has the same types of rules on it that are absolutely prohibited from being released to the public. This is not terribly unique at all in terms of the types of discovery that our office and every defense lawyer's office should be equipped to handle. The other big thing here is that this problem is, I think there are probably many counties in the state that do not uphold Brady the way they should, but this problem is unique in how extreme it is in Multnomah County. Grant, if you could go to the next slide. This is an example. I used to work on the major felony team in Washington County. This is what compliance with the rule of law, with Brady, what that can look like. This is not something that would be impossible for the local district attorney to uphold. All it is this is an example of a letter that we would receive in discovery that notifies the attorney who is assigned to the case, hey, heads up, this officer, in this case it was a former police officer, was subject to an internal affairs investigation that addressed the issue of dishonesty. If you want to review these records, you're free to come to our office and review them. If you want a copy of these records, go get a protective order from the court and we'll release a copy to you. We, as a matter of routine, and it is surprising, and Multnomah County should be somewhat disappointed that Washington County is so far ahead of Multnomah County on this issue. But we get letters like this as a matter of course in Washington County, including for current police officers, including for officers who are currently under investigation. It doesn't mean that the material is released widely to the public. It just means that it's basically an acknowledgement the defense is entitled to this material and that there are many situations in which it is truly critical to providing our clients a defense. So it's workable. The solutions exist. Here's an example of how it can look.
And so just to kind of conclude here, because I think we definitely went over our time, these changes, again, seem to be the direct result of our office discovering this policy, beginning to hold the PPB and MCDA accountable, as a mere 3 months later, there is a proposal to dramatically change the policy in a way that would directly counter the way that we were litigating and would prevent MCDA from really fulfilling what is their constitutional obligation. And it's a constitutional obligation because it ensures a fair trial. And that is important. Grant was mentioning Washington County. Washington County has a pretty bad reputation when it comes to the criminal legal system, especially within the defense community. It is seen as far more harsh. I can tell you, I've been practicing here in Multnomah County over 10 years. I've never received a letter like this regarding police officers. I have handled plenty of cases where I myself have discovered officer misconduct and have asked the DA about it and have had to go through those lengths. That should not be our role. It is the prosecutor's role to provide this information. And doing this also wastes a tremendous amount of attorney time, because if this process is not in place, what we need to do is file what's called a Cartwright motion in every case, asking, are there any misconduct records that are relevant to this case for the officers involved? That takes a lot of time. That wastes the time of the defense attorneys, the court, the prosecutors, the city attorney's office, who then comes to quash that information. So it is a waste of time. But again, above all, what it really does is undermine really the underpinnings of our democratic society, right? The right to a fair trial, the right to confront the witnesses against you. You cannot confront the witnesses if you do not have adequate information. I believe that is all we have at this time. Happy to take any questions or save that time. I know we probably went a bit over.
Yes, thank you so much. So what we're gonna do now is hear from our PPB policy folks, and then we're kind of gonna open it up to questions and discussion with all of our attendees here and comments from the public. We did want to flash this on a slide. We got this in the chat from Officer Jovic, who received this message from the district attorney in response to requests to attend this meeting. So we did just want to include this this statement here. I'll just leave it up for folks to scan if anyone missed it in the chat. If anyone wants to read it out loud, feel free, PCCEP members, but we can also just continue to refer to it in the chat.
I think it would be valuable to read it out loud, and I volunteer to do so just for the record.
Go for it.
So the statement from the DA's office in their absence says the language in Directive 0320 was always intended to facilitate MCDA's robust Brady review process through its potential impeachment disclosure committee. During the course of recent litigation, it was determined that the directive could be interpreted to permit MCDA full access to any PPB officer's personnel file for any reason. This was never MCDA's understanding of the original intent behind Directive 0320 and is grossly out of step with every comparable jurisdiction we are aware of, including every other law enforcement agency in Multnomah County. PPB consulted with us as it worked to revise Directive 0320 to clarify its original intent, and we think PPB has found a good balance to protect the privacy rights of union workers while also retaining and strengthening the notification and disclosure provisions necessary to ensure MCDA is fully compliant with its constitutional and statutory discovery obligations.
Thank you, Leslie. And we can refer back to this as needed if folks want to look at it as we discuss. So now, in the interest of time, let's just turn it over to Ashley from the PPB policy team. And thanks for being here, Ashley. So PCCEP did just want to prime engaging with you with these two questions and then anything else you want to share. So I'll turn it over to you now.
Thanks, Dory. DC Jovic, did you want to say anything? If not, I'm happy to proceed.
Yeah, just real quick. I appreciate the presentation. Chief Day would have preferred to have been here tonight as well to address everyone. Unfortunately, he had prior commitments. We did extend this the review period. We want to take in all community input that we possibly can. And that includes this conversation as well. All of that will be used when ultimately the chief and I make our decision on where we land on this. It's unfortunate that everybody isn't at the table to have a full conversation about this, because there clearly is some disagreement, and I wish we could hash that out in a complete conversation. Unfortunately, that's not an option right now. So my goal tonight is just to take as much back to the boss as possible, and we can sit down and write a policy that, you know, kind of balances the needs of our employees, the community, and you know, recognizes and considers the rights of the defense. So with that, I'll just turn it over to Ashley. Thank you.
Thanks, Chief. And I want to thank both Grant and Drew for the intro to Brady, the 101. It's a really complex legal subject, and it was helpful even for me. So I thank you for that, and for doing more of a deeper dive than I intend to do on the directive itself. I'm going to offer more of a high-level overview of the current policy, the 2022 policy, and where we are now, how we got here. And hopefully Doria will answer the two questions that you posed for me, but if not, please nudge me to do so at the end. Again, I think Kip also mentioned this in the intro, and the Grants and the Drew and Drew as well. We created the policy and enacted it in 2022. And there were a couple of forces at play that informed the development of the policy, but the primary source, of course, was that 2017 IPR report. The primary recommendation that came out of the report was that the Bureau develop a policy to establish a consistent practice that was understandable to both Bureau members and community members. Within the report, there was also acknowledgement that despite the absence of having a policy, that PPB did have a practice prior to the existence of a policy, albeit insufficient and woefully inconsistent and inadequate. These are not direct quotes, but the general theme of that report, and I believe the Grant shared an excerpt from that as well. But I bring that up because even in the absence of the policy, PPB still needed to fulfill its legal obligation to notify the DA of Brady material. And you know, I think it's an important point of emphasis that in the absence of a policy or the inadequacy of a policy, it doesn't absolve the PPB and ultimately the DA of its responsibility to meet this legal requirement. And we'll get into more of the purpose of the directive here in a second. But that IPR report also recommended that the policy speak to what constitutes Brady material. So as the Grants covered before, exculpatory and impeachment information, or as I understand it, I am not an attorney, so put simply and stated plainly, exculpatory information being information that could help prove the innocence of a defendant, and impeachment information essentially being any information that might challenge the credibility of, in this case, a Bureau member who is a government witness, so testifying on behalf of the government. The IPR report also recommended that the policy specifically address how we notify prosecutors of the existence of potential Brady material. So there was the IPR report. At the time, DOJ strongly supported that recommendation from IPR as well. And we obviously ultimately adopted and agreed with the recommendation. And that's how we landed on the current policy that's currently published on our website. It was the product of significant collaboration with the then DA's office, the Department of Justice, and IPR, as Drew pointed out, when he offered that excerpt of the executive summary that we put out at the time. So all of that is true. A lot of collaboration went into the development of the current policy. So as to the current review, we initiated the review for a couple of reasons. First of all, it was overdue for review. It was due for review in 2023. And I'll be the first to admit that sometimes we are unable to stay on top of our deadlines. We have to prioritize other policies, and this was one of those that just fell into that bucket. So it was long overdue for review. And then, of course, there was stakeholder interest, DA interest, in revisiting it. So we approached this review through the lens of trying to reconcile and recognize that the directive is somewhat of an articulation of a very complex legal principle, Brady, like their entire presentation. having to sort of narrow that into our directive. But also that the primary purpose of this directive is to convey the administrative procedure by which the Bureau will notify the DA of potential Brady material. And I mention that because it's an important point that informed some of the changes that we made to the policy, not all of them. We tried to, one of our primary objectives was to simplify the directive. We received many comments in the 2020, during the 2022 review and the current review as well, indicating just how difficult it was to understand the policy. There's a lot of legalese. And so I will concede that perhaps in an attempt to simplify the policy and make it digestible for all audiences and focusing on that administrative procedure, that we perhaps did lose some of the foundational principles of Brady. And I'm speaking specifically to those policy paragraphs. And so I think there's certainly room to revisit that language or possibly reinstate the language. It was never our intention to undermine those principles of Brady, and so I think that may have been lost in that process or that attempt to simplify the language. The other major driver behind the change to the policy, as I almost said the Drew's apologies, that the Grants and Drew touched on, was the DA involvement in the policy. So we did narrow the notification standard. I would maybe frame it a little differently than I apologize. I can't now recall if it was Grant or Drew that touched on this. We're altering or narrowing the point at which we inform the DA of allegations. And I think the credibility piece is an important part that I'm hoping that either Heidi or Mike can speak to. But we certainly narrowed the notification standard, which the city attorneys will speak to in a moment. But more broadly, the shift aimed to both address the DA's concern about the interpretation of the current policy, which I think is reflected in the statement that they provided, and to more closely align the standard and the policy when we notify the DA with other local jurisdictions' practices. A theme that came up in some of the comments that we've received so far was I think there's a perception that the proposed changes will somehow adversely affect the way we conduct administrative investigations, that it might somehow alter the definition of misconduct or what constitutes misconduct, and that there would be a change to our reporting and investigation procedures, or perhaps the corrective action guide. And this policy, the proposed changes, and I keep using the word proposed because we have not adopted any of the changes that we've put out. But the proposed changes would in no way impact the accountability system in that way. And that's kind of a through line that has come up in some of the comments. Before I hand it over to the city attorney's office, I do want to just briefly speak to the second universal review process and how meaningful of a step it is in our process. I think there is a little bit of a misunderstanding about our review process in general. So the first universal review process, I think folks on the call have referenced us posting the existing policy and then a couple months later putting forth the proposed changes without explanation. So the first universal review process involves the Bureau posting its current policy, giving folks an opportunity to review and comment on our current practices. So put simply, it's our way of saying, hey, this is how we're doing this thing. We want to hear from you. We want to hear about the impact. We want to hear about recommended changes, et cetera, et cetera. So that's the purpose of that first universal review process. We then take the comments from the first universal review. We discuss those comments internally. We meet with stakeholders, and it informs the development of the proposed draft that we then ultimately post for the second universal review period. And so that's the draft that the Grants and Drew discussed tonight, was the proposed practice. So this was our practice, first universal review, second universal review. This is what we're proposing. So we received a high volume of comments. I think it was 250 at last count. by far exceeds the level of engagement we've had on other directives. So I think that highlights the importance of this issue. One of the questions that Dory posed was just the PCEP wanting to get a sense of the nature of those comments. I would say it is abundantly clear that there's overwhelming opposition to this policy. I haven't read all 250 comments. We do intend to read all of them and to discuss them with the chiefs and other internal stakeholders, but some of the common themes that surfaced from the comments were perception of distrust and reduced transparency through the proposed practice. Again, the sentiment that this would somehow negatively impact our accountability system, our investigation and reporting misconduct and reviewing misconduct process. And generally, folks tend to reject the idea that PPB should be in the business of making the determination of what constitutes a credible allegation. So that was the kind of the common through line through the 250 comments. And I thank everyone on the call who has submitted comments. But I want to again emphasize that we haven't implemented any of the changes. We welcome this discourse. This is part of the process. It's the primary objective of this stage of the process, the second universal review process, is to get this kind of feedback. A couple of folks have mentioned, the chief mentioned, we extended the comment window. Both PCEP and Portland Cop Watch requested some additional time to comment on the proposed draft, particularly in light of this conversation. So we're happy to do that. And folks are also welcome to contact me anytime, even outside of the review cycle, if you have questions or concerns about a policy. But I'm going to stop there and hand the baton to either Mike or Heidi. I'm not sure who's going to step in. I'm not an attorney. I am not an expert on criminal law. And certainly with Brady, there are labor law implications as well. And so I'm hoping that one of those folks can speak to sort of the legal obligation, the existing legal standard, whether or not the proposed policy comports with the law. I believe that it does, but they can speak in more detail to that, and possibly to the various constraints on meeting the obligation as well. So with that, Mike, Heidi, I don't know who's stepping in at this point, but handing it off to you.
Thanks, Ashley. Hi again, Heidi Brown. I use she, her pronouns, and I'm from the city attorney's office. And I think there's a few things that were presented about the changes to the policy that I want to highlight that I can understand why it's getting misread, but it's a misreading of it. So if you look at section 1 of the policy and the amendments, there is a duty to identify and report potential exculpatory evidence. So that when there's an allegation that is sustained allegation of potential Brady material, which is the material that Grant and Drew shared, that information is reported to the district attorney's office. In addition, the section that they were highlighting about when there's a credible allegation that includes Brady material. If you look down, so if you look in section 1, you see the duty to report all sustained allegations of potential exculpatory evidence. And the definition of what that is earlier, but it's the things that were on that wonderful training that Grant did, which clearly he's very good at that. And then if you look down at section 3 of the potential amendments to the policy, you'll see that there's an affirmative obligation to notify the district attorney's office when there's just an allegation. So we haven't even gone through an investigation. There's no finding made. There's nothing. This is just the start. Somebody has said, I believe this officer was untruthful. When we get that, well, when PPB, sorry, this is a PPB policy, not city attorney's office policy, but when PPB gets that allegation of untruthfulness, that gets reported to the when they open an investigation, excuse me, into untruthfulness, that gets reported to the district attorney's office. So where you saw that letter, Washington County letter, that was where in that instance, it said that they had found that an officer had been dishonest. So now you're talking about at the end of an investigation, you have a full investigation, you've looked into the claims, and then you've made a finding. So and what this policy would do if it's adopted, and it's, as Ashley said, it's still under review, and the Bureau is welcoming more feedback, and we'll consider what was said tonight as well as other information. But under this policy, any allegations where there's an investigation opened against truthfulness on a Bureau member, that will get reported to the district attorney's office. Okay, so now I can't answer for the district attorney's office on how the practice has been. I understand that MPD and Metro and Grant and Drew have had concerns over the years, and I'm sorry to hear that. And I can't answer for that. I can only talk about the city and the policy that we have. And then in addition to that, we're talking about what is PPB going to affirmatively notify the DA and say, hey, we have something. Well, in addition to the open investigation on truthfulness, if there's one of those allegations that somebody lovely, Odelia, thank you. Odelia put them in the chat, so you can see the different type of allegations that are considered Brady material. When there is a credible allegation, not even a finding that it's sustained that the officer violated our policy, but just a credible allegation of that is also going to get affirmatively reported. And then if an investigation is not truthfulness, and at the initial analysis or throughout the investigation, it hasn't risen to that level to be deemed a credible allegation, but if at the end it goes through and it's sustained, again, then the notification will occur. So the big difference that I see in the existing policy as it is now, and the one that's being proposed and is under consideration, is that right now what the policy says is that all administrative investigations and all supervisory investigations are available to the district attorney's office. So some of the things that were in Grant's presentation that he's like, yeah, we don't need to know about excessive absences. We don't need to know about maybe an officer's rude, but not in a biased way that demonstrates, a bias against somebody based on their protected class status, but they're just rude. That is a professional conduct allegation. It gets investigated. If it gets sustained, that doesn't have to do with Brady. So in those instances, as Grant was saying, that's not the kind of thing they're looking for. So what we did was just the change in the policy is simply to say that we're focusing on what is Brady material. That information will be affirmatively provided to the district attorney's office, as I stated. So I just wanted to clarify that because I think that there were misunderstandings about when you read the policy, because there's that affirmative obligation that comes in earlier, but it always happens on a sustained finding. So I hope that helps. And I'm also happy to try to answer questions less on the criminal law end of things and more on our policy.
Thanks, Heidi. So
yeah, thank you.
As everyone can see, we are definitely running long. 7:30, and this meeting is scheduled till 8. I do want to move to kind of creating some dialogue around this, and perhaps we can kind of have some engagement between our guests and also questions from PCEP and the public at this point. We also still need to hear from Juan from OJRC. So perhaps yeah, just trying to figure out how to make the best use of the limited time we have. Juan, do you wanna take it from here, and then we can open it up to dialogue?
Sure, and truly, MPD's presentation covered so many of the points that I was prepared to make today. So I'll do my best not to repeat that. But as far as I see it, I don't see how this is a misunderstanding of what the text is, respectfully to the city attorney's office. Those allegations of excessive force, mishandling evidence, that is pertinent Brady information. Failing to turn that over will result in mistrials. It will result in post-conviction appeals. It will result in cases just languishing for months, years even. And that serves really no public interest. Neither the victim, potentially who's waiting for a day in court, who wants to argue, to speak, or certainly for the person who's languishing in jail or in legal limbo. And so these aren't trifling matters, and truly, I don't think we can privilege anything above the due process rights of criminal defendants. That is baked into our Constitution, quite simply, and has been reaffirmed time and time again. And I'll just highlight one thing that came up in the last few years. It was actually a situation that grew out of Brady material that was not turned over in Wasco County. In 2021, the new DA looked into the drawer of his predecessor and found a memo from 2011 saying from another DA who said, "Hey, I was looking into vehicle code and I actually found a report that this officer had been demoted because of untruthfulness that wasn't turned over." That seems important for us to know. That memo was buried not only by the Dallas Police Department, but also by the Wasco DAs. And thankfully, that DA did the right thing and ordered mass case review. But that is the consequence. That is the consequence of not being transparent, if not providing these materials early to the defense so it can be vetted, so it can be put in front of a judge for in-camera review or for review under a protective order. There are processes in place. This doesn't, again, nearly impact the officer as it does the criminal defendant. So I do believe that this current directive in any form will backfire. The present directive 320, I think, does accomplish a lot of the legal obligations under Brady. I do have reservations about the DA's office being the arbiter of what is or isn't exculpatory, but at minimum, at least in their possession, and at least there are rules of professional conduct and court oversight over the conduct of DAs more than there is, frankly, of police officers. And so, as it stands, I think that is the best policy you can have, and I see no purpose in changing this. I have not seen an officer's reputation get dragged through the mud in one of these criminal prosecutions. More often than not, it's people getting, sitting in jail for too long while they are endlessly trying to get discovery in their own case. What you have right now is clean and simple. And frankly, that protects not only the criminal defendant, but also the city. If there is, in fact, new evidence that's discovered at a later juncture and it was shown that the city was the one who didn't hand it over to the DAs, that's a malicious prosecution lawsuit. And unlike a lot of other kind of public bodies, DAs offices are absolutely immune to civil liability. The city, not so much. There are other immunities, of course, but the city would be left holding the bag because the DA didn't want to ask for something that's inconvenient for their lawsuit. And that just hurts us all fundamentally. So I can think of hypotheticals where that situation comes to pass. And primarily, you know, I think it's driven by the fact that we just cannot allow the police to police themselves in this circumstance. We know from, you know, the past that conduct that was deemed unconstitutional, or in the case of you can Google him, Corey Budworth, criminal, that the Bureau still didn't think was actually violative of their own directives. And you know, I don't think we can allow the Professional Standards Division then to be the arbiters of what is or isn't exculpatory at this juncture, or at that early juncture in a criminal prosecution. And as the MPD brought up, this is discoverable. It's just hard to get when it's not in the DA's possession. It requires these Cartwright motions that drags in the city, it drags in the DA, stops criminal, you know, prosecutions while you're trying to figure out what is or isn't in existence. That drags out these cases, and you know, MPD is you know, probably too nice to say that they are you know, like all public defense offices in the state, currently suffering from understaffing, underfunding from the state. We just are exacerbating a crisis that we have in the underrepresentation of criminal defendants. And frankly, I find it hard not to think, based on the DA statements, that that is indeed intentional. That if it is pushed onto the DAs to have to file these Cartwright motions, they are going to exploit the fact that the PD's offices are far less resourced and far less able to go seek those documents than they are. And fundamentally, it is their affirmative obligation to do it in the first place. And so I see this ostrich strategy of just not, you know, if it's not in my possession, I don't need to turn it over. It is inapposite to the constitutional order, and will just result in these things prolonging, and lawsuits, and people getting hurt fundamentally in our criminal legal system. And as NPD noted, there are so many procedures and processes in place to make sure that these records aren't being disseminated wildly. My opinion, and the opinion of our office, is that the current directive should just be let to stand. I don't see a purpose in changing it.
All right. Thank you very much, Juan. As stated in the chat, you know, we're going to try to get as many people to share either their question or comments about our discussion, or what's been shared so far. Conrad, go ahead and go, and then we'll take Kip, Odelia. If you do have a question or comment, please raise your virtual hand or wave at me so that I can see you, and I'll make sure I'll get you in queue.
Thank you so much, Afrida. Thank you, everyone who presented, and the lively conversation. I just wanted to frame this a little bit because it seems like I don't want to get lost in the molasses and sauce of all the proposed directives. I'd rather go to the start, you know, from the business side of what is the problem we're trying to solve. And at this point, I don't think there's a clear, present, or compelling reason from the city or the PPB about why we're implementing any directive changes. And I don't even feel comfortable or confident making a comment on any of the changes until we have the reason we're making the changes. So we have something to measure up against in the interest of public transparency. I don't think that's an unreasonable ask. That's the most frank, polite, professional way I can address it to our wonderful representatives. Thank you all for being here tonight. But I think that's the core issue. And I'll speak for myself, but what I would advocate for the rest of the committee, I don't feel comfortable talking about the minutia of these directives until there's a clear, present, and compelling reason why. I'm so glad this is the one moment I get to use the one time I took the LSAT. Okay, I'm done.
All right.
Was that a question for PPB?
For the city, yeah, I think. Yeah.
Yeah, that was mainly just to frame the conversation of, before we have a bunch of directive questions or rationale questions. I think we have to go to the heart of the matter before we can even address things downstream. So, I mean, everyone should have the right to ask what they want to ask, but I think that's the biggest call out while we have representatives from the pertinent parties here is why? And there may be very good reasons. I just don't see that as of this moment.
And I might take just a quick stab and then I'll turn it over to somebody at PPB. I can't say for sure why or what, but I can note that, as I said, the current policy includes all allegations all administrative matters and all supervisory investigations. So these can be the full gamut of any kind of conduct allegation, any kind of policy violation. So one of the changes that this will do is focus it in on Brady material. This is a Brady policy. And then also my understanding is that when PPB looked into it, that other jurisdictions in Oregon, that our policy was, because it had all those administrative matters included, it was much broader. So we're trying to just keep it in line with other jurisdictions. And when you're including allegations that aren't Brady and types of cases that are not Brady, then we get into, as Grant was talking about earlier, maybe it was Drew, sort of your due process issues from the labor end of things, which is part of what I work on for officers. And it's not to say, it's still very important that Brady material is turned over. Criminal defendants absolutely have a right and need to have that information. And it's just setting up how that happens, that the information is given to the district attorney's office. So just in answer to your question, Conrad, the current policy, if you take a look at it, it's extremely broad and covers everything far beyond Brady material.
Just to piggyback off of that, Heidi, this is Ashley Lancaster. You mentioned, you referenced other jurisdictions, and we're not aware of other agencies that have an on-site review process or practice currently in place. So that's when Heidi says we have a broader policy in addition to the stage at which we're notifying the DA being a little narrowed. And the proposed policy, the on-site review, we removed that. And I think the grant spoke to this as well. And that was largely because we weren't aware of other agencies that had that practice. And the proposed policy, the draft policy reflects what we believe to be the most common administrative practice. So just kind of a slight restating of what Heidi just said as well.
Thank you. And just really quickly, the biggest call out, I think, is that we haven't seen any of that in writing. So we can't make, an appropriate public input without understanding what we're being graded against. So if we could have something, just a one sheet, just a white paper, that would help frame the discussion. Otherwise, anyway, I'm done. Sorry, we got to get on other things.
That's understandable, Conrad. And I will say, we kind of a recent practice of ours, when we post a draft policy for TUR, we've started providing on the website, which I don't love our website, I'll be honest, but there is a little blurb beneath the TUR process that speaks to varying degrees, why we're making some of the changes. I will admit, I don't think that we've gotten into the level of detail that we've discussed on this call in that little blurb, but that's something that Dan Handelman had previously pointed out. It's helpful to understand what motivates the change, and we're trying to address that. I don't know that we have the resources to put out a white paper every time we post a policy, but we certainly do that in the executive summary at the end of the process, and we've been trying to include a little bit of information that provides some insight into exactly what you're highlighting there, Conrad. But we can certainly do better, and we'll take that into consideration.
All right, go ahead, Kip.
Yeah, thank you for all the background and conversation. And Conrad, again, I really appreciate framing the why, because it still feels unclear to me. And no disrespect to anyone, but Heidi, I think you mentioned the goal was to simplify the directives, and I am more confused by the changes than I was the original one. So I don't find it being more simplified. But without getting into the minutia, like Conrad said, there are two major challenges that jumped out to me. One is this is a critical function of right to a speedy and fair trial, right? And all of the redlining under the policy section, whether you're trying to simplify or not, seemed really unnecessary and made me feel really uncomfortable. That looks like everything but section 2 and maybe 6 become two pieces of it. And I'm going to just keep going for the sake of time, but from a trust standpoint, that was concerning. On top of that, my understanding is Brady material is a subset of exculpatory material or evidence, and all the different changes of the wording seemed odd to me, and I don't understand how that makes a difference to anything. But again, it just confuses the whole process of trying to review this. But the big thing that I do want to call out is while it was mentioned that in section 3 there's maybe even a potentially, again, I can't read it that way, but a potentially wider set of information that should be presented to the DA and possibly the defense. But it seems predicated on section 1 and 2, where it seems like the members of the PPB make the determination themselves whether or not they feel the evidence falls under Brady or exculpatory, and what is the motivation for them to make that decision on their own and then decide, oh, we don't have to flag it this because we don't feel it is. It again speaks to a huge trust challenge, especially based on some of the history that was presented tonight. So I think overall, the goal of making this simpler and clearer was not met. And I don't know that there's a question there, but I want that to be understood that I don't see those arguments presenting themselves in this version of the directive changes.
Kip, just really fast on your question of the exculpatory evidence clearly includes bias, truthfulness, evidence mishandling. So the things that were in the presentation from Metro PD's office, Public Defender's office, those things that they were talking about, that's Brady material, those are types of policy violations. So where you're saying, how does the PPB know if they have an allegation like that? It's because that will be what the allegation, they'll open an investigation. Was an officer untruthful? Did an officer engage in bias-based policing, evidence mishandling? So those kinds of things, or excessive force. So that's how they know that section, that you get down to section 3.
Yeah, but they make that determination themselves necessarily, because anyway, that's how it reads to me. Maybe that's not the intent of it, but that's kind of how it reads, that they could act in bad faith and just say, no, this isn't relevant. So
I think Heidi, I think go ahead, Ashley.
Heidi, I think there are two components to the policy. We've placed most of the emphasis of this conversation on the potential exculpatory impeachment information as it pertains to internal affairs investigations. I think the section 1.2, which Kip, correct me if I'm wrong, but I think that's the section that you referenced. That's more directly related to member responsibilities as it pertains to their investigations, like criminal investigations that they're conducting. So they would make the determination based on the contents of the reports, their investigation, their criminal investigation themselves, as to any potential Brady evidence that exists within their investigation or within their reports. So 1.2 is more connected to sections 2 and 2.1, excuse me, and 2.2. Section 3 is kind of the second component of Brady material as it pertains to administrative investigations of Bureau members. But your point is well taken, Kip, and we'll make sure that that's abundantly clear when we revisit the draft.
Okay, thank you. Yeah, I'll yield the floor. So,
Odelia?
Yeah, first, I guess I'm wondering if anyone from MPD wants to respond to some of the things, or OGRC to some of the things that Heidi or PPB has shared, because I see some disagreement, so just want to make space for it.
Okay, Drew, do you want to go?
I'm happy to. I also want to be respectful of folks who haven't had a chance to talk. I think there is significant disagreement here. I think I've made clear in my comments, I do not understand where the credible allegations component comes from. I don't think that this policy is less confusing. I think it's much more confusing, and these are pretty clear categories of misconduct that we need to use, that we need to be able to see. And the only way we're getting anything is if an MCDA attorney has reviewed it first. I think for the due process question, this is important, and I just want to address it. Officers obviously should not have their misconduct records just broadly publicized to everyone in our community. That is not what we are asking. That is never what we think should happen. What should happen is that specific records that have been reviewed by a deputy district attorney, that have likely then been reviewed by a judge, that have gone to the defense lawyer only under a protective order that restricts them from talking about it with anyone, usually from even giving a copy to our own clients of those records, and then that the rules of evidence restrict what actually would even come to light in the public light of a trial. That's what we're talking about here. And so I think putting a choke point within PPB for these records, it's hard to see how it's serving the broader purposes of this. And to the extent officers have confidentiality rights, we've litigated this with the city. Courts have ruled repeatedly that those rights, that whatever due process or confidentiality, whatever you want to call it, for officers of not having these records reach the public view, those are sufficiently protected by everything that I just laid out. And also, they don't trump a criminal defendant's right to a fair trial. That's the person whose liberty is at stake here. And we're talking about people who are witnesses saying that someone committed a crime. It isn't just someone from the public trying to grab these officers' misconduct records to talk about it in the public space. And I just think that's really, really important to remember here.
Thank you. Yeah, I think definitely as non-lawyers, it's hard to see the disagreement, right, and the back and forth. And it's super concerning as well, and it's concerning because it sounds like the DA's office isn't actually acting in compliance with this rule, and then to make it stricter sounds like it's just going to prevent people from fairness more and more. And so I guess at the end of the day, what this comes down to is, from my understanding, a policy that's trying to protect police more and more, and also the city. And so that just feels super harmful and unfair. And I think, yeah, it's interesting too, because at first I thought this was just a policy that was being changed, but I'm wondering how much it was pushed by MCDA and how much that's really fair in this situation. and if it was pushed by the city attorney's office or how that all came to be. But another thing I'm wondering is, it seems like, not to speak on behalf of all of PCEP, but at least for myself, like this is a major concern, and I hope we can continue to make sure this policy never, the new policy doesn't ever come into effect. But I'm curious if there's ways beyond just, it seems like the MCDA clearly isn't holding up their line and things, but are there other ways to improve the policy, the current policy as is, that you would like to see beyond just like people actually doing what they're supposed to do?
Is that question directed toward anyone in particular, Adelia?
I guess MPD and OJRC. Yeah.
Grant, do you mind? I
Yeah.
think
Go for it.
honestly, it would be great to see what this policy actually looks like if all the actors, mainly MCDA, from based on what we've learned in this conversation, are complying with the policy, and are acknowledging that they have these records, reviewing them, and then turning over what they've determined rises to the level of Brady. We don't even know that that's happened, so I don't really understand. Again, what are we fixing? We don't know that there's over disclosure because there isn't even disclosure in the first place because MCDA is not doing its job. And this is beyond the scope of this meeting. This isn't the only Brady and discovery violation MCDA is committing. And it is exacerbating the public defender crisis. Like Juan said, it is overturning convictions. It is getting cases dismissed. And I really wish they were here so that they could hear everyone's comments and be more accountable. Parzybach, the case we cited in our presentation, it wasn't only dismissed because of these Brady violations, it was dismissed because they didn't turn over poll cam videos from the protests in May that they had for months, and they never gave them. And so it's all just to say this is part of a broader pattern from our district attorney's office, and an elected district attorney who's a longtime member of it. And I think that there needs to be answers from them about why they aren't doing their jobs.
Barb?
Hey y'all. I'm curious about what is covered in terms of what is expected to be turned over to the DA, in terms of like there's ABLE training that the officers have gone through and they're supposed to be able to react and do that. That doesn't seem fair for that to go into the Brady pile. But in a way, the way you're describing it, it maybe should. And then also like the employee information system, that information also, it's just not clear what is expected there. And then my other question is, did Dan and or did Mr. Handelman and or Copwatch have a chance to comment on either review?
Yeah, there's some of Dan's comments on the second universal
Okay.
review,
Thank you, Kip, for that part of it.
or from the first universal review, sorry.
Yeah, and folks from Copwatch are here too, so maybe they can share more of that.
Right.
Or in the
Like,
chat.
okay. I kind of wanted to hear an answer about the ABLE and the EIS and stuff, either from PPB or from one of the grants, I guess.
I don't know that the Metropolitan Public Defenders folks will know about our the Bureau's ABLE policy. It's active bystander policy of having officers report when there's misconduct by another officer. So if you look back earlier in the chat, I think the Odelia posted some of the slides that Grant and Drew had presented that shows what's generally Brady material. And so you would just look at those and then look at the PPB directives that comport with those. For example, the truthfulness directive, the bias policing directive, the directive on evidence handling, et cetera. Those will be the policies that would be impacted.
Yeah, and just to dovetail onto that, the EIS system does not include misconduct. That's, excuse me, held in a separate file in internal affairs, so that would not be included in that. And I was unclear on your question about the ABLE policy, but any informal conversations that weren't documented would not be included.
Okay.
Thank you, guys.
Thank you, Barb. And just so you all know, we're going to go to 8:15, hard stop at 8:15. If you have to leave right now, that's completely understandable. We are recording this conversation and will be placed on the website. So we're going to take these last two hands here. Go ahead, Chris.
Sorry, I was going to say, I think Devontae's had his hand up longer than I have, so
Okay.
he can go ahead of me.
Okay, go ahead, Devontae.
I'll make it pretty brief, but you know, I think, you know, Conrad had a really good point in it, you know, why, to what end, you know, I don't intend to call anybody out, but I think that it's just overall a really unfortunate situation because people who are being accused or having to navigate the justice system, you know, are entitled by the Constitution to, you know, and do have the right to a speedy and fair trial. And I think that regardless of what the underlying motives may be, I don't see how, in any capacity, this is going to benefit the city or PPB as far as building trust with the community. When we look back to like the PSU protest or the demonstrations / riot after during the time frame of George Floyd, the city of Portland, and just like the way that the city of Portland is perceived nationally. I don't see how this is going to, in any way, shape, or form, contribute to the restoration of community in the city. There is going to be a lot of community unrest. As you guys mentioned, going through like the 250 comments, Ashley, is that you guys are going to review all of them, but that there's a very common and clear theme in that nobody appears to support this, that the general consensus is from the community or from the public feedback is that it's going to be incredibly destructive to the the purity of the justice process. To what end is what we have to gain from, or the city, the district attorney or PBB have to gain from changing this directive? Is it going to be worth more than the potential negative impacts to changing it in the first place? So that's just all I'll kind of comment and leave with that. So yeah.
Okay, go ahead, Chris.
I know we have a few more people that'd like to speak, so I'll try and be as quick as I can, and I won't be able to go into as much depth as I want. But if people want to contact me, they absolutely can. Two things I would like to address is one point of contention I've seen is how do we deem what is a credible allegation? And I want to make sure that people understand that when we look at what a credible allegation is, the bar for that initially is set really low. We don't just take something and look at it on the surface and say, this person made this complaint. Nope, don't think that happened. And then we ship it off and it goes away off into the ether. We actually do conduct intake or IPR, do conduct intake investigations for those to see what do we have? Are there other places we can go? So please don't think that we're just looking at these on a very surface level and then we're just getting rid of them. We actually do a little bit more legwork up front to make sure that these allegations are investigated. Two, there's a comment made, I believe it was during the public defender's presentation regarding how over time, excuse me, Portland Police Bureau's findings such as sustained and the allegations have changed over time. I can't comment to that because that's been going on since, long before I got here. What I can tell you is that being the person who receives these requests for Henthorne and Brady, when I get those, I don't just run a member's IA history and look for those specific criteria and say yes, no, yes, no, yes, no. When I see sustained, I will actually go into the investigation. I will look at the allegations and see what they were. And then I will go through the investigation to see, is there anything in there that could potentially be Brady material, at which point I will disclose that. So again, we're not just doing this skimming surface level look and sending things off or not sending them off. We're actually doing a little bit more of a deeper dive before we send this off, because we really, really want to make sure that we are complying with applicable laws and directives. So again, that's super fast. I apologize because I know we're running short on time, but I want to give other people a chance to speak.
All right, thank you, Chris. Charlie.
Thank you. So I am coming to you strictly from as a community member, although I am part of Cop Watch. Just listening to everything this evening, I have to and always have had to trust my instinct. Well, I'm going to tell you how I'm feeling right now about this as a community member. The same way I felt when Bush took us into Iraq. Okay. So I wasn't a political person. It was just like, what the hell's going on? And so this feels like more of the same that I've witnessed for decades in decisions that are being made to benefit the police and the city versus community members. This feels like liberty and justice has been further stripped away. Fair trials is being further stripped away. It feels deceptive, untrustworthy, and unconstitutional. And as Chief Day is talking about, oh, our police, our community members, we are trying to do everything to earn your trust when you continue to do things that do the opposite and make decisions that do the opposite. We're not blind out here as community members. And we're not stupid. We see what's going on because we get the brunt of your decisions and not in a good way. And so my question is, how do we stop this? Thank you.
Thank you, Charlie. We're going to go ahead and go to the next comment, but your question, we're going to have the co-chairs are going to just briefly review like what things can be done from this point moving forward, Charlie. So I don't want you to believe that your question isn't going to be answered. We'll have some direction here at the end. Barbara?
Thank you all. I would just suggest that to Ashley Lancaster and the city's attorney office, that they look at what was going on in Washington County. If people say they're doing well, why not? Follow some of their example.
Thank you, Barbara. Okay, I'm going to turn this back over to the co-chairs. Co-chairs, if you can also add to what's possible, what's next that folks can do in order to stay engaged and push this conversation up. I see you, Dory.
Sorry, I'm going to get in the question line. I just have a process question based on MCDA's comment, where how I read their comment did seem to suggest that there was a level of collaboration on the directive with PPB. And I don't know a ton about how that process works with other partners that PPB obviously has on some of these directives. But I was just wondering if either Heidi or Ashley or anyone else could clarify.
I'll respond to that. It's
okay, cool.
There absolutely has to be a collaboration with MCDA on this policy because we're disclosing information to them. So the answer to your question is yes. Just like any other outside partner that we would collaborate with, our policies reflect
Okay,
collaboration.
that makes sense.
Yeah.
Yeah, I think that's just information that is new to me from a process standpoint that I would like to learn more about. So that's helpful. Thank you. And I think I'm the last comment. So sorry, Afrida, back to you.
That's okay. That's okay. I'm actually going to turn it back to the co-chairs. And just also, yeah, next steps. Wonderful.
Yeah, I guess I can jump in. So first of all, thank you, everybody. I appreciate the, once again, honest and often challenging conversations we all have in these meetings. I think it shows to an intent of talking through complicated things. So it seems from this viewpoint and a lot of the conversation, plus some of the feedback from Ashley, that there are some maybe some reconsiderations that need to happen with this policy or directive change. From a PCEP standpoint, when we do a recommendation, it's usually a pretty long process. So if it's going to become a recommendation, we will take that up with the full committee. But in the interim, there are 2 more weeks for everybody to provide input from, and that includes PCEP as individual members. So I suggest everybody take advantage of that. And as far as making it into a recommendation, we will pursue that later on. I think it also warrants revisiting some of the directive around the directive review, which we've talked about in times past also. So all that being said, Tia, anything else you want to add? Or
Tia,
Sorry,
if you're
I'm muted.
oh, there we are. Okay.
No, I can't think anything tonight because I'm just feeling really overwhelmed and tired, but
That's
just
fair.
thinking about making sure everyone knows how to make public comment, and then as PCEP members would like to make our comments, how to move forward. I just want to make sure that we're all moving forward and can come back together, and appreciate everyone's time.
Do you mind if I just say something real quick? I just want to thank you folks for the conversation and let you know that I've been taking notes throughout this whole thing, and I really appreciate everybody's input. It's part of an active process to come up with a good policy that's workable for everyone, right? So that's what this process is for. So I appreciate your input, and I will make sure I take this back to the chief for our final decision.
Thank you for that, Casey.
So we are going to have some open public comments, simply because it's just a commitment that this space has. And so we'll open the floor for that. If you have any comments about or questions about what was discussed today or any other work that PCEP is doing, this is the time and opportunity for that. Go ahead, John.
I'm sorry, I didn't, maybe this was answered. I just had a quick question about who makes the final decision. I would hate for this to be like a kind of like email your representative, but they're really gonna make a decision with or without our comment either way. Or like who's actually making the final decision?
I'll go ahead and answer that. The chief
On the directive
makes the
itself.
final decision on policy matters.
Chief.
Okay. All right.
John, I will just add to that. One of the authorities that this body has, that PCEP has, is if PCEP does pursue formal recommendations, although they can't compel the mayor or the chief to take any particular action, it does require a formal response. So it is a little bit beyond, the typical feedback loop or lack thereof that you might experience in other spaces. So I'll just mention that as well.
Odelia?
Yeah, a bit of a different topic, but I have a question for folks at the city and PPB. We saw our first ICE arrest in Portland on Monday at an immigration court and another one today. And I know we've heard from the mayor and the chief of police that they wouldn't comply with ICE, and this is a sanctuary city. So I was really hoping for some clarity on if PPB did have a role in that, or if you know of that, or what's happening there.
We absolutely had no role in that whatsoever. We don't station people in courthouses. We don't do any of that. So we had zero role whatsoever, zero knowledge that it was happening, no role whatsoever.
Gotcha. Thank you. Do you know if there's a plan on like the city's behalf to have that stop?
Well, our plan to have it stop is not to have it happen on city facilities, right? So ICE has its own jurisdiction. They act independently of the Portland Police Bureau or the Multnomah County Sheriff's Office as their own law enforcement agency. They have the autonomy to go and make arrests as they see fit. While we don't actively help them, we also don't stand in the way of them because they have federal jurisdiction to do so.
And I just want to clarify, so the city has a sanctuary city policy, the state has a sanctuary law, and we are a sanctuary city, as many people know. And but part of that is if there's an area, like a city area that's open to the public, we can't tell like an ICE agent, oh, everybody but you can come in. So we're not allowed to do that. But areas that are not open to the public, unless they have a search warrant for that area, then our policy is not to allow them into those non-public areas.
Okay. Babs?
Hey, so my little pea brain is about ready to explode. So I'm glad we are closing. And thank you to everyone for being here. I took notes, I took screenshots. I'm not sure I totally understood everything, but I will do my best. So when does this group, PCCEP, meet again? And then on that note, I'm hoping we can say good evening to each other. Thank you.
We will cover that in the next slide, so we're exactly on the same page, Babs.
Okay, thank you.
All right, wonderful. Let's go ahead and turn it back to the co-chairs.
Okay, what's next? We will be having our next meeting on June 17th. Our steering committee is from 6 to 8. I can't. Sorry, I just moved something.
Yeah.
Thank
So,
you. Go
I'll
ahead.
just say the steering committee will be a little different than our typical open meetings like this. It will we will be streaming it, so it will be publicly available for view. And we will have an open public comment period at the end. But unlike kind of the back and forth dialogue that you typically expect in our meetings, the steering committee will be more narrowly focused on discussion between the PCCEP steering committee to set that longer term agenda. But of course, we do still want to hear from you, so we will have that period at the end. And then we will have our regular full committee meeting on June 25th, which is a Wednesday. And yeah.
Okay, great. Thank you, PCCEP members, members of the public, and accessibility support for your contributions today, and all of the guest speakers. Thank you so much for your time. And to learn more about us, our website is portland.gov PCCEP. Community members can give written public comment in advance to our meetings at tinyurl.com PCCEP comments. We really hope you do that to help us guide us in our recommendations and comments as well. Please sign up for our email updates at tinyurl.com PCCEP emails. Great.
Thank you so much, everyone. Thank you to all of our
Thanks, everybody.
very helpful, informative guests. We appreciate everybody. Have a good night.
Thank you. Good night.
Thank you, PCEP. Have a good night.